In Part 5 of our 5-part webinar, CMP and NTSO Complaints, Jessica Tierney with the Office of Compliance and Enforcement will go over the hearing process for those who've received a civil money penalty or no tobacco sale order complaint, including what happens before the hearing is conducted, during the hearing itself, and after the hearing. Coming up now in this edition of FDA's Tobacco Compliance Webinars.
Thank you for watching Part 5 of our webinar on CMP and NTSO complaints. I'm Jessica Tierney with CTP's Office of Compliance and Enforcement. This webinar is the last in a series of 5 webinars for retailers and small businesses. This webinar will focus on understanding the civil money penalty, also referred to as a CMP, and no tobacco sale order, or NTSO, complaint processes. Specifically, we will focus on the hearings process for CMP and NTSOs. The other 4 webinars focus on Part 1, Introduction to CMP and NTSO Complaints, including a list of common terms compiled into a glossary and general information on what retailers can do after receiving a complaint. Part 2, How to pay a CMP using the online payment portal. Part 3, How to file an answer and the consequences for not filing an answer. And Part 4, the settlement process. All 5 webinars are available on the FDA Tobacco Compliance Webinars page. To access the webinars, visit www.fda.gov and type FDA Tobacco Compliance Webinars in the search bar. Follow the FDA Tobacco Compliance Webinars link in the search results to find all available webinars. The webinars are organized by year. You can watch all 5 webinars in order or skip ahead to a webinar topic of your choice. During this webinar, we will discuss what is a hearing, how to request a hearing, who conducts a hearing, what happens once a hearing is requested, what happens at the hearing, and what happens after the hearing. Retailers have the right to a fair and impartial hearing to determine the outcome of a CMP or NTSO complaint. Hearings are a formal process conducted on the record to help an administrative law judge or ALJ determine whether a retailer is responsible for a CMP or NTSO. If the ALJ decides that the retailer is responsible, the hearing will also help him or her in determining the appropriate amount of a CMP or the duration of the NTSO by considering any mitigating factors. You can have an attorney represent you during the hearings process, but it is not required. The hearing process begins when you submit an answer to the complaint. Filing an answer or requesting an extension to file an answer are discussed in the 3rd webinar in this series, titled How to File an Answer and Consequences for Not Filing an Answer. As explained in the How to File an Answer and Consequences for Not Filing an Answer webinar, your timely filed answer is considered a request for a hearing unless you state otherwise. If you waive the right to a hearing, the presiding ALJ may decide the outcome of the complaint based on documents and arguments submitted by you and FDA's Center for Tobacco Products. Hearings are conducted in accordance with rules set forth in Part 17 of Title 21 of the Code of Federal Regulations. The regulations can be found at the website address listed on the slide. Or using your internet browser, you may use the search terms Code of Federal Regulations, Title 21, Part 17, to find the regulations that set out the procedures for CMP and NTSO hearings. CMP and NTSO hearings are conducted by the Civil Remedies Division of the Department of Health and Human Services Departmental Appeals Board. We also refer to them as the CRD. The CRD employs ALJs to oversee these cases. An ALJ is the presiding officer in an administrative hearing. The ALJ is impartial, independent, and qualified to conduct the hearings on the record. Some examples of an ALJ's responsibilities include setting the date and time of the hearing and deciding requests for extensions, receiving evidence as part of the hearing, issuing rulings on admissibility of the evidence, In other words, deciding what evidence is allowed to be considered. Controlling the course of the hearing and the conduct of the parties. Ruling on procedural and other motions. Determining whether the retailer is responsible for the violations alleged in the complaint, and determining the appropriate amount of the CMP or duration of the NTSO. An ALJ is not responsible for conducting settlement negotiations. However, the settlement process and hearing process can occur simultaneously. Our fourth webinar in this series explains the settlement process with FDA's Center for Tobacco Products. Now let's move on to what happens once you request a hearing by filing an answer. Once your answer is filed, the ALJ will send the retailer and FDA's Center for Tobacco Products an order. The order is often called an acknowledgement and pre-hearing order. The title and format of this order can vary depending on which ALJ has been assigned your case. Generally, the pre-hearing order tells you and FDA's Center for Tobacco Products the procedures for presenting evidence and arguments in the case. It also lays out important deadlines for the different steps both sides have to take before a hearing date. For the purposes of this webinar, we will call this order the pre-hearing order. Here's a sample of what you might see when you get the order. More specifically, the pre-hearing order notifies you and FDA's Center for Tobacco Products of the name and contact information of the staff attorney assisting the ALJ. Summarizes the documents that FDA's Center for Tobacco Products and the retailer must file or submit to each other and to the ALJ. Establishes due dates for submitting documents and provides format requirements for such documents, such as page limits, procedures for marking of exhibits, and how to send documents to the ALJ and to the other party. Pre-hearing orders also establish procedures for discovery of documents. Discovery is the process by which a retailer or FDA's Center for Tobacco Products makes a written request to the other party to produce documents that are relevant to the issues before the ALJ. Here's an example of what a pre-hearing order may say about discovery. Pre-hearing orders will also state that both parties must submit a pre-hearing exchange, describe the contents of such pre-hearing exchange, and provide the deadline for each party's pre-hearing exchange. The pre-hearing exchange may require the submission of an informal brief. The informal brief will answer a series of questions relating to the specific issues that the ALJ must resolve to decide the case. If required, you or your attorney, if you are represented, must respond to the questions on the pre-hearing order attachment titled Informal Brief of Respondent. CTP will supply responses to the questions in the attachment titled Informal Brief of Complainant. The pre-hearing order will require each party to also submit a list of proposed witnesses and its exhibits, which must include any documents the party intends to use during the hearing and the sworn written direct testimony of any witness the party intends to rely upon. It is important that you submit your pre-hearing exchange, including the informal brief if required, witness and exhibit list, and exhibits by the due date set forth in the pre-hearing order. The DAB provides free language access services and translations throughout the process. Pre-hearing orders also provide information on how to access the DAB's language services. This service is available for free if retailers require assistance communicating effectively with the ALJ during the hearing process. If your pre-hearing order does not provide you with information on language access services, you can contact the DAB at 1-844-880-5720 for assistance. It is important to read through all the requirements set forth in the ALJ's pre-hearing order. Failing to meet these requirements may result in consequences, such as sanctions, which can include the ALJ finding you liable and imposing the full penalty sought by FDA's Center for Tobacco Products. If you have any questions about any of the ALJ's orders, the ALJ's staff attorney can assist you. Submitting an answer is only the first step towards obtaining a hearing, and additional steps have to happen before the ALJ will schedule a hearing date. Prior to the hearing, the assigned ALJ may hold a pre-hearing conference or meeting with you and FDA's Center for Tobacco Products. Not all ALJs hold pre-hearing conferences, but most ALJs do, and they will inform both parties of a pre-hearing conference date and time by mail or e-file notification. The pre-hearing conference is conducted by telephone. The ALJ will issue a separate order with a date and time for the conference as well as a conference call number. During the conference, the ALJ will clarify the issues to be decided at the hearing, identify the witnesses who will be questioned during the hearing, who will be the witnesses each party identified in its pre-hearing exchange, and for whom the parties had timely submitted their written sworn direct testimony, and set a date and time for the hearing that is acceptable to all participants. Now that we have discussed what happens before the hearing, we'll now discuss what happens at the hearing itself. When the hearing is conducted, the following people will usually be in attendance: the ALJ, who presides over the hearing, staff attorney, who is assigned to assist the ALJ, an attorney from FDA's Office of Chief Counsel on behalf of the Center for Tobacco Products, and representatives from the FDA's Center for Tobacco Products. You, the respondent, your attorney if you have one representing you, witnesses for both sides, and a court reporter to record the hearing. Like the pre-hearing conference, hearings take place over the telephone. All participants and witnesses are required to call a conference call number. The ALJ will send you a document with the hearing date, time, and the conference call number. If you have special circumstances that would make a telephone hearing impractical, please contact the ALJ staff attorney as soon as possible. As a reminder, the staff attorney's contact information can be found in the pre-hearing order. During the hearing, the parties can present evidence in the form of documents or through witness testimony. Documentary evidence is included in the parties' pre-hearing exchange that is filed prior to the hearing. Documentary evidence can include photographs, videos, reports, and sworn witness statements. These documents are also referred to as exhibits. Witness testimony is made under oath. It is important to remember that each party must submit the sworn direct testimony of all their witnesses in writing with their pre-hearing exchange. At the hearing, the other party may question the witnesses about their written testimony. This is called cross-examination and is the only oral testimony allowed at the hearing. The respondent or their attorney will be permitted to pose questions to FDA's Center for Tobacco Products witnesses, and FDA's Center for Tobacco Products can pose questions to respondents' witnesses. The presiding ALJ will determine what evidence and exhibits can be considered in the hearing. The ALJ will not make a final decision about liability for the CMP or NTSO or the amount of the CMP or length of the NTSO at the hearing. The ALJ's written final decision is issued after the hearing is conducted and post-hearing briefing, if any, discussed in more detail shortly. Let's now discuss what happens once the hearing is complete. After the hearing is complete and the presiding ALJ has accepted evidence into the record, a written transcript of the hearing will be produced. The retailer and FDA's Center for Tobacco Products reviews the written transcript. Once the transcript is available, the parties will be given the opportunity to submit a document called a post-hearing brief. A post-hearing brief is submitted after the hearing is complete. It may discuss what happened at the hearing, and it may summarize any arguments or legal issues regarding the facts of the case. The ALJ will set a due date for the post-hearing briefs once the transcript becomes available. After the post-hearing briefs are submitted, the presiding ALJ will consider all arguments and evidence presented in the case. The ALJ will then issue a ruling called an initial decision. The initial decision will contain the ALJ's findings regarding whether the allegations in the complaint are true, whether your actions violated the law, whether you are liable for the charged CMP or NTSO, and if liable, what is the appropriate amount of the CMP or duration of the NTSO. If the presiding ALJ finds you are liable for a CMP, the initial decision will set forth the amount of the monetary penalty and will explain when the decision becomes final and binding on both parties. FDA's Center for Tobacco Products will notify you by letter when the penalty is due. If the presiding ALJ finds you are liable for NTSO, the initial decision will set forth the number of days that the NTSO will be in effect. FDA's Center for Tobacco Products will notify you separately by letter of the exact dates that the NTSO will be in effect. If the presiding ALJ finds the retailer is not liable for the alleged violations in the CMP or NTSO complaint, the ALJ will not assess a CMP amount or order an NTSO. If the retailer or FDA's Center for Tobacco Products is not satisfied with the ALJ's decision, Either party can appeal the initial decision to the DAB. Appeals must be submitted within 30 days after the initial decision is issued. And how to appeal the decision is included with the initial decision that is mailed to the retailer and FDA Center for Tobacco Products. This concludes our discussion of the CMP and NTSO hearing process. To summarize the material we have covered in this webinar, we have discussed how you can request a hearing by filing an answer, the ALJ who presides over the hearing and the ALJ's responsibilities, what happens before your hearing date. Specifically, we discussed the ALJ's pre-hearing order, discovery, the pre-hearing exchange, including the informal brief, if required, the witness and evidence list, the evidence including sworn direct witness testimony, and the pre-hearing conference. What happens at the hearing, including how the hearing is conducted, who attends the hearing, and how documents are presented by both parties. What happens after the hearing, which includes release and review of the hearing transcript, submission of post-hearing briefs, the ALJ's initial decision, and the ability to appeal the ALJ's initial decision. Now that we've covered the procedures involved in CMP and NTSO hearings, we encourage you to visit the other webinars in the series to help you understand the CMP and NTSO complaint process. The previous webinars in the series are Part 1, Introduction to CMP and NTSO Complaints. Part 2, How to Pay a CMP Using the Online Payment Portal. Part 3, How to File an Answer and Consequences for Not Filing an Answer. And Part 4, The Settlement Process. All 5 webinars are available on the FDA's Tobacco Compliance Webinars page. To access the webinars, visit www.fda.gov and type FDA Tobacco Compliance Webinars in the search bar. Follow the FDA Tobacco Compliance Webinars link in the search results to find all available webinars. The webinars are organized by year. Thank you for watching Part 5 of our webinar on CMP and NTSO complaints, brought to you by the FDA's Center for Tobacco Products, whose mission is to protect our kids and the nation's health from the dangers of tobacco.